Hello, everybody. Meow. Hi, tiny kitten. Hi. Oh, you okay there, girl? You okay? Ava, it's okay. I need a couple dozen ox to open this window now. Hold on. Oh, no, don't go. Oh, no, don't close. Oh, it closed. Well, that was that. Hi, guys. Hi, Ava. All right. Can I help you? No, Snitch, back it up. I gotta reach the treats. Okay. Here's yours, Ava. Your guys' is coming. Oh my. Let me. Extra camera. Share it. Add it. There we go. All right. Put Ava's up here. All right. Guys, to the tower. No, it doesn't work like that. Here, Ava. Ava! Billy's on the tower. Billy knows the drill. Last one, Eva. Last one. Good girl. I had to get myself some fancy new compression stockings because my pharmacy made a goof with one of my medications. And it caused major blood pressure spikes for like 5 days. And it made my legs swell really bad, and the swelling hasn't gone back down yet. So I have compression stockings, and I have a box under my desk to prop my legs up on. And I've been sleeping with my bed in the feet all the way up, head all the way down position. So hopefully it'll go back to normal. I don't have a problem with my legs swelling until they mess with my medications. And they goofed big time. And they made me go cold turkey off of medication that you're never supposed to go cold turkey off of. And yeah. Oh, what I hate is that I didn't know that when your legs swell, you get water blisters. I didn't know that. So when I was really curious about what it was and I pushed on it and it popped, it hurts. You're not supposed to do that. So, yeah. Hello, Buzzy Pug, honey. Hello, Nana Laura. Hello, Eileen and Carlin. Hello, Wire Mother. Hello, Jerry Matthew Boyd. I hope you're feeling better, buddy. Hello, Squishy. No. I've had those. And they're not pleasant at all. When I was hospitalized, the last time I went into respiratory failure, they had me hooked up. Well, actually, the last 2 times, they had me hooked up with machines directly to the nurse's aide's office. And yeah, every time my O2 would drop, I think it was 83 or 86 was the threshold. And all of a sudden, every alarm in the institution would just go blazing. That'll wake you up. And they were having a really difficult time getting my O2 to stay up. So, yeah, it went off every time I dozed off. You be good, Ava. You be good. I hear you. That's okay. I'll keep you up to speed as much as I can. The hearing tonight, so there was a hearing 2 weeks ago that I don't have. And I wish I did. I don't know if it was the same cast of characters or not, but tonight's is a motion for attorney's fees. And they're arguing. Good? You good? Snitch just waltzes in. Tiny kitten just bolts, climbs up the back of my chair. Snitch just waltzes slowly. It's like, I'll get you, my pretty. But yeah. I got stuck on this hearing for like a half hour. I didn't even watch the whole thing. I was like, I'm gonna run this. I have to. Hello, Jen Callum. I was sitting here waiting. No, it's a thing. What was that? You're not even making cat noises now. Those aren't even cat noises. Those are like demon spawn noises. Stop it. Go back to cat noises. I love you. You knocked off my elbow pad. And you did it on purpose. Do you know what a pain in the butt it is now to get that? I gotta get my legs off the box Reach down, get it, then get my legs back on the box. Wipe your fur off my desk. Why does that one piece not want to come off? I suppose I'll give you your little handful off to the side. Since you can't get over to the towers without the boys getting you all riled up. There, emptied that one anyways. Oops, that one on the floor. All right, hold on, I gotta, no, snitch. You go get the treats from the tower. I know what you're doing. You're gonna no. No. You're gonna leave her alone. That's what you're gonna do. All right. I had to get my feet back up on the box. Okay, we're good. We're good. Time keeps flowing like a river, and just like a dam, it pools in my calves. Hello, Mortimer Duke. Cats are being cats. Hello, Dark Zoomy. I'm all out of action for the night. That was a pretty good stand. Yeah, she did good on that one. I was expecting her to dance, and I think she would have if I didn't have the three. Well, the Jerry bag, and then the spinner toy, and the toy that holds this thingy, and this rolls around inside of it. Yeah, it's charging. Hello, Purple Kiv. Oh, promise me if Jenna Green shows up, I would have to wish her a belated happy birthday. Oh, you're too sweet. She'll love that. Hello, Spider-Man. Yeah, Jen Kellum. It did that to my dad. It did that with my dad. I didn't know. I'm still learning all of the joys of this old people shit. And it can stop now. Take me back. Take me back a few years. I'm not ready for this. All right, let's get into it. Wow, we only have 9 people here. We're gonna start early. Earlier than normal. Hello, Penny. I'm in a screen that I can't click on you. I feel your tail.
All right, Mr. Lopez, you got everybody you need?
Your Honor, I'm missing Ms. Torres. I understand she has an in-person court hearing and she'll be joining us just a little bit later, but we are ready to proceed without her.
Mr. Ullman, same question to you. You got everybody you need? You're muted, sir. Still muted. I can't hear you.
Apologize, Your Honor. Yes, we have everybody we need.
All right, then as to testimony, if you're going to testify today, raise your right hand so we can swear you in.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I do.
Okay, as I recall, subject to correction, that Mr. Ullman had rested and completed his questioning, and we were to Mr. Lopez on cross-exam on expert on his attorney's fees. Is that correct?
That's my recollection, Your Honor.
I mean, I had passed the witness. I had not rested, but I passed the witness. Yes.
All right. Then, Mr. Lopez?
Yes, Your Honor. May I proceed?
Yes.
Thank you. Mr. Ullman, you just mentioned a moment ago that you had passed yourself as a witness but had not rested your case. Is that
Correct.
your understanding of where we are procedurally?
Yes, and by that I mean I perhaps have a redirect depending on your questions, and I may have some redirect based on your last 2 weeks ago questions. But other than that, I have no intentions of calling another witness.
And you agree with me that procedurally we're at the same point we are now as we were at the conclusion of our last hearing on the 26th?
I guess I can agree with that. I'm not sure. I mean, I had passed myself, and you were in the middle of cross, and that's where we are.
The hearing had not yet concluded on the 26th when
That's
we
correct.
recessed for the day.
That's correct.
And as we sit here today, the hearing has not yet concluded, correct?
Correct.
Now, at the wrapping up of the business day on the 26th, you actually had suggested to the court that the court could just rule on the motion right then at that moment, didn't you?
If I recall,
Mr. Lopez, what are we doing here?
yeah,
If you have questions about his testimony, that's one thing, but procedural issues, I don't know that that's a proper avenue for you to pursue at this time.
Well, Your Honor, the reason that I'm asking is because $101,000 has been requested in attorney's fees for over 1,000 violations. Our theory of this case is that this case has been overpapered and overworked, and I just want to
Well, that's not for you. This is not closing argument, sir.
As you will find out, Mr. Lopez pursues many theories that he probably shouldn't travel down those roads of, but he likes to.
If you have questions for Mr. Ullman, ask him.
Okay, then I'll ask him something different than that. The motion was not ready to rule on at the time that you suggested that the court cut to the chase and just ruled, was it?
that is not that's not accurate of what I stated that day, but
Didn't you suggest to the court that the court could just rule on this motion by?
Sir, one more
Yes.
time. If you have questions about his attorney's fees, ask them. If you don't, we'll move on to the next witness.
Your Honor, the fees that are incurred relate directly to the approach that has been taken in the case. And to make a determination of whether those fees are either reasonable or necessary, the approach to the case, I think, is well considered, or should be considered by the court in determining whether the fees that have been asked for have been incurred reasonable and necessarily. And the argument that I'm making, or the point that I'm making, is suggesting that the court step outside the bounds of the rules and step outside of procedure and spending time arguing about that. And this is not the only, well, and I understand that, Your Honor, but this is not the only instance. And whether Mr. Ullman charged Ms. Clark for that, and that is now seeking to effectively charge Mr. Clark for that, that is relevant. That is whether it
it's
goes to
relevant
whether
if you want to point out some specific fees from his testimony that you believe are pertinent to that. That's one thing, but we're not going to spend time just listening to argument about whether or not he proceeded in the case the way you wanted him to. That's out
and it has nothing to do with my preference, Your Honor. It has everything to do with the rules of procedure. And that's all I'm asking about. I'm not asking about whether he should use one type of font on his pleadings or one filing.
That's okay, but I'm not going to spend an hour listening to this. If you want to attack his fees somehow, that is entirely appropriate, and I invite you to do it. But I don't want to just hear some general argument about the way this case has proceeded. you're going to have to tie it to some specific concern about the fees.
And I will, Your Honor. I just respectfully ask for some leeway. We are here on a motion for enforcement where incarceration of my client is sought, where attorney's fees of over $101,000 have
I know
sought.
all that. I know all that.
And I'm just making my record, Your Honor. And Mr. Ullman has used now our fourth day to present his case while we have had motions waiting and pending that we have not had relief on. And if
Sir,
we,
you're winding around the road. Either get on to cross-exam about attorney's fees. This other stuff about how many days it's taken, that's not entirely his fault. He's put on a lot of stuff, but he's also been bound by the schedule of the court and the procedure by the various attorneys your client has had in this case. So let's just go to the matter that we're here for.
Mr. Ullman, how much of your 101 attorney's fees request for this motion for enforcement relates to alleged violation number 1?
I cannot answer that direct. I can't, I have not, my time entries speak for themselves that are in I think they're exhibit P23 that's in.
Mr. Ullman, you would agree with me that in order to proceed, or excuse me, in order to prevail and in order to receive attorney's fees on a request, the requesting party needs to prevail on the underlying motion.
Yes.
Okay. And so in order for you to receive attorney's fees for violation number 1, you would have to prove violation number 1, wouldn't you?
Okay. Objection. It calls for a legal conclusion, Judge.
We're not here to
So
argue the law, sir. That's not for you and the witness to do. That's for me.
Your Honor, this witness has offered testimony as a expert trial lawyer, as a board certified family lawyer, as a board certified civil trial lawyer. He has the experience and the expertise to answer.
I heard it all. I heard all that background. We know about his resume.
Great. And so when he qualifies himself as an expert in the law and a board certified trial lawyer, he opens himself up to answer questions about the operation of the law as it relates to his request for attorney's fees on those violations.
He opens himself up to questioning, sir, about justification for his rates. This
Okay,
is not a debate about the law. I'm not going to listen to you argue with him about the law.
Perhaps, Your Honor, if the court could tell us the court's understanding of the law, so we don't have to argue that point as to whether a person has to prevail on a motion in order to receive attorney's fees.
No. Here's the judge's interpretation of the law. Someone makes an objection, judge sustains it or overrules it, and you move on. You do what the judge says. That's the law. The judge, he'll tell you along the way.
Well, you don't get to ask me that question.
Okay. So, Mr. Ullman, I'm going to ask you again because you didn't answer my previous question. How much of your time and attorney's fees relate to violation number 1 as alleged in your motion for enforcement?
I don't have it divided per the violations. And my exhibit P23 that was introduced and admitted as evidence speaks as to the exact time entries. If you'll look at them, you can see the
objection, non-responsive.
I'm attempting to answer the question, Your Honor.
Yeah, objection's overruled.
Okay.
Sorry. Objection is sustained.
Okay. All right.
Actually, I've got it backwards both ways. The objection by Mr. Lopez is overruled.
Okay.
And
so
he's trying to answer the question.
All right. So I can't answer that. If you will study, and I don't know if you had time to do it, but if you would study exhibit P23, you will see that it precisely lists the original motion, the supplemental motions, the amended motions. And if you have had time to look at those, you can see and identify where I raised each of the violations. So one would naturally appear to be in the first motion, and you can look at the times that were prepared for that.
Objection non-responsive. Your Honor,
But
I got disconnected and Mr. Ullman is still going. I asked him a very basic question on how
I'm sorry, sir, you're disconnected?
I disconnected and Mr. Ullman was still talking after I was able to reconnect. So I'm asserting my non-responsive objection at this time.
All right, you don't have to explain all that, Mr. Ullman. You've told him where the information is.
Okay.
That's
okay,
Your Honor, I didn't get to hear Mr. Ullman's answer. If he could briefly tell us
He
again.
referred you back to the exhibit that he had referred to before.
Okay. And so, do you have that exhibit in front of you, Mr. Ullman?
yes, sir.
Okay, can you tell us now after you take back your office and your associated experts and counsel on violation number 1?
I lost part of your question.
Yeah, you cut out.
If you would please take a look at your invoice and tell me how much attorney time between yourself and your associated attorneys and experts was spent on preparation of violation number 1 in your motion for enforcement.
I don't have the invoice. I thought we were referencing P23, and P23 is an accumulation of all of the work extracted from our invoices that are related to the enforcement action. So I don't have an invoice.
Is that to say that you don't, is that to say that you don't know, that you can't answer that question?
I don't, you referenced an invoice. I don't have an invoice in evidence, and it's not before me.
Okay. With respect to the exhibit that you did offer, and I may have called it an invoice, excuse me, the exhibit, how much attorney time, expert time was spent on violation number 1?
At this time, Mr. Lopez, I can't calculate that. I would have to study the P23 that you've had possession of since our last hearing. So I cannot answer that without taking substantial time to look at likely the original motion. And then it's going to be impossible to determine that. For example, let's assume there were 10 violations in the first.
The objection non-responsive.
I can't answer the question, Mr. Lopez. It's in P23, but I have not had time to study that to answer that question.
Mr. Ullman, what about alleged violation? Okay, before we move on to alleged violation number 2, let's start with number 1. Did you pursue violation number 1 today or at any time during our 4-day motion for enforcement hearing?
I'll have to, I mean, it was in my testimony. It was in also the testimony of your client. I'll have to.
Objection non-responsive.
I can't answer that
Objection
question.
non-responsive.
Sir, let him answer. Maybe it's responsive.
I can't answer that question without studying the invoices and looking back at the prior testimony.
Thank you. So at least with respect to violation number 1, I want to make sure that we're clear. You don't know, you can't answer right now how much time between attorneys and experts was put into violation number 1.
Correct.
You can also not answer whether you even pursued violation number 1. Is that correct?
That is, I would have to look at the past testimony and the prior.
I can wait.
It's of record what was discussed. This is what the 3rd or 4th hearing we've had, and I don't recall specifically at what hearing we addressed the specific violations. It's of a record.
But you are the attorney that is sponsoring the testimony that's requesting attorney's fees, aren't you?
If you will look at Exhibit B1.
Objection non-responsive.
No, okay. All right,
Objection non-responsive.
Okay, and repeat your question.
Objection non-responsive. Your Honor, the question was whether he is the attorney that is sponsoring the request for attorney's fees and offering testimony in that regard.
Yes.
Okay. You, like we discussed, are not able to provide an answer in this moment without doing some studying on whether you pursued violation number 1 or not.
The answer is in evidence is Schedule B1. And B1 has, which is in evidence, has a list of every single violation we're prosecuting. And as I look at it, again, which is in evidence, number 1 is one of the violations we're seeking punishment for, yes. It's on the second page of B1. If you'll take a
Okay,
look
so
at it.
and what amount of attorney fees are you asking for or to number 1?
I don't have it segregated. They're cumulative of the 56 that we're prosecuting.
56 of your violations, of your alleged violations, support a $101,000 attorney's fees request. Is that
Yes.
correct?
Yes.
So when Mr. Trent's testified earlier that he had charged 9.2 hours or 7.2 hours in drafting of the first motion for enforcement, you agree with me that we are not pursuing the first motion for enforcement, right?
I disagree with that.
Well, you amended the enforcement, didn't you?
Correct, but as you well know, counsel, or should know, you don't have an amended enforcement
Objection,
without.
non-responsive. Objection.
May I answer, Your Honor?
I thought we weren't debating the law, Your Honor.
I'm
Well,
answering.
I thought we weren't debating.
Right. The answer is you cannot.
Sorry, Your Honor. I didn't hear Your Honor's Your Honor's comment.
The objection's overruled.
So we are arguing.
You gotta let him say enough to know whether that it's relevant or not.
He was beginning a soliloquy of his understanding of the law, which I understood Your Honor had previously barred us from doing.
And I did. That is correct. But I didn't get
And
it
so
to the soliloquy, so I need to hear enough to know how to rule, if you want to rule it.
Okay. The question is, Mr. Ullman, you did not pursue the motion for enforcement. You pursued a first amended and supplements to that motion for enforcement. Is that correct?
We are pursuing the amended motion, but there is no amended motion without an original motion.
Okay. And so which motion is the violation number 1 that you mentioned contained in?
It was in the original motion,
Which I'm
and
pursuing.
it's in the amended motion also.
And you cannot tell the court how much in attorney's fees or expenses you spent on number 1.
No, because there were several.
I can ask for why. Objection non-responsive.
Okay, no, I cannot isolate between each of the 56, correct?
Okay. And did you do any preparation for your testimony today?
Yes, yes.
You didn't think that that would be relevant for the court to consider when you allege 1,000 violations and only pursue 56 on how much was spent on each individual violation?
Objection, I think that calls for a legal conclusion.
He's an expert, Your Honor.
I think he's answered the question.
That he thinks it calls for a legal conclusion?
Restate your question, please.
How much of your 101,000 attorney's fees request relate to alleged violation number 2?
I can't segregate it without, all I can do is refer you to the detailed time entries that we made in exhibit P23.
You would agree with me that you have pursued less than 10% of the violations that you have alleged?
Yes, yes.
Yet you are seeking 100% of the attorney's fees incurred in the drafting and preparation of that motion.
Well, he did the work pursuing the original 999 violations. And yes, some of them they ultimately ended up not pursuing. But that doesn't mean he didn't do the work. And lawyers, they have to be very detailed. But I'm hard-pressed to believe that every time they start writing a word on a page for a particular motion, they write down what time they started. And then if they're working on multiple motions at once, I mean, how does that work? Do they have to, divide the minutes up between the three? Like, he's being very, very, very nitpicky, and it gets worse.
Objection, relevance.
Your Honor, the attorney's fees have to be reasonable and necessary and related to the violations that are proven by preponderance of the evidence. If there's no attempt to even try, then they shouldn't get attorney's fees for violations they don't even attempt to prove in front of Your Honor.
Well, let me ask a question, because maybe I'm missing the boat here, Mr. Ullman or Mr. Lopez, in that my understanding of where we sit right now is that he in fact has itemized each charge. What he hasn't done is group them the way you want him to have them grouped.
So I suppose that's one way that you could characterize it, Your Honor, but it's not myself that can group that way. It would be any reviewing court and the Court of Appeals that would determine if it, for instance, let's say that Mr. Ullman can prove violations 1, 2, and 3, and then the remaining 997 are not proven or pursued. But attorney's fees as a lump sum is granted on everything. At that point, attorney's fees are being awarded for the other 990 something that weren't being pursued, which isn't allowed by the family code. So if I make 10 allegations and I only decide that I'm going to pursue 3 of them, then I have to tie my attorney's fees to those 3 allegations that I'm asking for relief on, not the ones that I just decided not to pursue. And we've got other arguments that we're going to be making regarding those as well, and the unnecessary attorney's fees that were incurred regarding that. But he's got to tie his attorney's fees request to violations he's actually brought before the court and pursued and proven.
Okay, I understand where you're coming from now. Mr. Ullman, do you wish to respond to that at all?
Just again, this is not testimony, but legal argument. I believe his argument is not founded. For example, one could have simply 3 violations. One of the violations may be for $1, one may be for 100,000, one may be $1 million. The amount of time in investigating violation 1, 2, or 3 may differ. They may not differ, but it's the court's discretion in looking and determining what is reasonable and necessary to have brought the 3 that I've given as examples. There is no case that I've ever seen where you have to numerically assess certain attorney's fees for each violation in a multi-violation prosecution. So I disagree with the legal argument being made by counsel.
All right, Mr. Lopez, next question, please.
Is there a ruling or thoughts from the court that we can help kind of guide where we go forward from today, Your Honor?
You can proceed with the question you had previously asked.
Thank you. With respect to violation number 2, you cannot tell the court how much was put into actually pursuing that violation.
I have not made that calculation, no.
Now, I have stood up in court and complained that these 1,000 alleged violations and only pursuing some of them has created some hardship on our preparation. Do you recall that?
Several weeks ago, yes.
I think I also asked you about it on the 26th, and you said you weren't really sure on whether alleging 1,000 violations and only pursuing 56 would create more unnecessary work for Ms. Torres and I. Do you recall that?
I do not recall making that statement. I'm not denying it. I just don't recall. I don't know. Objection, relevance.
Let's clear up your thoughts on that. When a motion for enforcement is filed, it is that attorney's duty to investigate and prepare for all potential violations that their client is facing. Is that true?
Would you repeat that question, please?
Yes, Mr. Ullman, I will. When a person is facing a motion for enforcement and an attorney is representing that person, that attorney has an ethical duty to review and investigate all of the alleged violations to be prepared to answer for them.
I would.
Is that true?
I would agree that's fair.
you would agree that that is fair. Do you
Yes.
agree with me that it is that attorney's ethical duty to their client and to their own license to review all of the allegations that are made, investigate, and prepare to defend them?
I think that's true. Yes.
Okay. And so when 1,000 violations are alleged, but only 56 are pursued, isn't all the work that the attorneys did on preparing for the other 940 or so, wasn't that sort of wasted effort on those attorneys' parts?
That's calling for speculation on my part because I don't know what the other counsel did in as I specifically, in response to your question, as I specifically recall, weeks ago, if not months ago, month or two ago, that was raised, and I tendered an order that had the 56 narrowed and gave. So the notice has begun weeks ago of those that we were going to pursue. And in fact, effectively, informally stating that we're non-suiting all of the others. And I've stated that position for weeks. And at your request in the court's direction, several weeks ago, I took the time in
Objection non-responsive.
Aransas County.
Objection non-responsive.
I'm gonna let him answer.
Several weeks ago, I, at the court's direction, went through every single of the 56, and I think there were maybe even slightly more, 60 or so. And we, at your request, identified each one, and at y'all's request, we identified every single pleading that was associated with each of those violations.
But you didn't do it the way he wanted you to.
And furthermore, we gave you the source documents for those violations. So I don't know why you have spent 1,000 studying the 1,000 when in fact weeks ago we narrowed it to the 56. So that's my recollection of the facts.
Okay. Your Honor, if I can show the witness a document to refresh his recollection. May I share screen?
Yes.
Thank you. Mr. Ullman, do you recognize the document that is on the screen now?
I believe so, yes.
Do you recognize the handwriting on that document?
I believe that is my paralegals.
Okay.
Right.
And you were just talking about a moment ago that we had raised the complaint of having 1,000 violations alleged, and your oral announcement to the court that you would only be pursuing a portion of those. We had requested that you amend your pleadings, and in fact, the court ordered us outside to confer about another matter, and your paralegal created this document. Is that your understanding?
I think that's my recollection, yes.
Okay. And I have this document because you and your paralegal tendered it to me, didn't you?
Yes, I'm not sure that's all of them, but yes.
Okay. Your Honor, at this time, I offer RX1.
Is that the complete document, sir?
Yes, Your Honor. This is everything I received from Mr. Ullman, RX1.
No, there was also a proposed order with the 56.
That's a separate document, Your Honor. I'm offering this admitted at this time.
RX1 is admitted.
Okay. Now, in conjunction with this document, you also tendered us a proposed order with the 56 violations. Is that correct? Mr. Ullman, you just told me about it. Mr. Ullman, can you hear me?
Okay.
Two.
Is there somebody helping you with your testimony, Mr. Ullman?
I can't hear you.
Is there somebody helping you with your testimony, Mr. Ullman?
Whoops. I'm sorry. I'm sorry. I couldn't hear you, but go ahead, counsel.
A woman's voice keeps coming through your microphone. Is there somebody helping you with your testimony, Mr.
No,
Ullman?
I had muted. I hit the wrong mute and hit the mute him, and I was asking my assistant how to unmute. Sorry.
Okay. In conjunction with the document that we just reviewed, RX1, you also came to court with a pre-prepared 56 violation proposed order. Is that correct?
I did a proposed order, Mr. Lopez. I don't recall if that had 56 or somewhat more. We eliminated a couple because of some typos. I recall that.
Okay, and so you agree with me that the RX1 that we just looked at and the 56, maybe a few more, maybe a few less order that you came to court with proposed are different, correct?
Slightly, yes.
Okay. You also agree that, or you also, you would also agree with me that the hearing commenced over our objection after we received the handwritten RX1 and the 56 violation order, correct?
I don't recall whether you objected or not.
Oh, because I thought you complained that we had asked for you to narrow down the issues, that we had asked you to replead, and that you didn't think any of that was necessary. Didn't you just testify about that a few moments ago?
I'm not sure what you're referring to in my testimony, Mr. Lopez.
Okay. We have previously asked on more than one occasion for you to narrow your pleadings, and have even filed a special exceptions asking you to do that, and you have refused, correct?
I don't recall you filing a special exception.
You don't recall us even having a hearing on our special exception and that the court denied it?
I I don't recall specifically that, no.
Okay. But even then, when we did ask you, you still refused to put in a pleading what your 56 violations were. In a singular pleading, rather.
My recollection, Mr. Lopez, is that y'all orally raised an objection when y'all
Objection non-responsive. Mr. Ullman, have we asked for you to consolidate your pleadings into one concise, uniform pleading?
You have orally asked that, yes.
Okay, and we've also asked the court to order you to do so, correct?
I think orally you did, yes.
And you refused to do so, correct?
I stated that I was not on notice for that pleading and that we had, prior to you making that oral request.
Objection non-responsive.
I had no notice.
Objection non-responsive.
Overruled. Mr. Holman, you may answer.
I never refused to do it. I was never on notice that you were asking, that you had special exceptions that would required me to have done that, but I voluntarily gave notice.
Objection non-responsive.
Overruled.
I voluntarily offered, and we voluntarily drafted an order that highlighted the specific ones that I told the court we were going to address, after the court stated in a prior hearing that we weren't going to have time to listen to 1,000 violations. And so I narrowed it to some that I thought were exemplary of the behavior that we were attempting to stop. And in addition, we voluntarily.
Objection non-responsive.
Sustained.
Okay. But you never did it, right? We should have made you do it. You didn't do it. Is that right?
Objection.
I'll withdraw the question. I'll withdraw the question. Do you have an opinion, or do you have any kind of, as a board certified family lawyer with the ethical duties that we talked about a few moments ago, do you have an opinion or do you have a feeling as to whether Mr. Clark paid any attorney's fees in order to prepare for this motion for enforcement?
I have no personal knowledge of what he's paid for.
Okay. Would it have been the prudent thing for his attorneys representing him to do to be prepared for the motion for enforcement?
I have no opinion on what his attorneys should or shouldn't do.
Your Honor, objection non-responsive. This attorney has offered himself as an expert in the realm of attorney's fees, as well as for motions for enforcement, family law, and civil procedure.
Objection sustained. You may answer, Mr. Holman.
Okay, you're asking me if I think that his attorneys should have prepared for this motion to defend the motion for enforcement? That's the
It would have
question.
been a reasonable thing for his attorneys to do.
It would have been a reasonable thing for me to have done, yes.
Okay. And are you different from other attorneys?
I'm quite sure I am.
Are there ethical rules that apply to you that don't apply to myself and Miss Torres?
I don't think so, no.
Okay, so we're kind of the same in that regard then?
We have the same rules of ethics, yes.
Thank you. Is there a reason why you chose to state it differently when I asked you about it?
I don't know what you're referring to, sir.
Is there a reason why you chose to differentiate yourself from the type of work that Miss Torres and I might do earlier?
I've never worked with you and Miss Torres, but I have worked with other attorneys that have not abided by the rules of ethics, if that's what you're asking me.
Okay. Let's just be very straightforward here. If any portion of your attorney's fees request was related to violations you did not pursue, should you receive attorney's fees for those violations?
Yes,
Why?
because you weren't in the case, but it took almost a year to get discovery. And once we got them in tranches of thousands. We had to sieve through those, mostly my paralegal and Miss Baumgartner, fortunately, and not my rate, to go through the over 16, 17,000 pages of records and to find violations, some minor, some grievous. And we had to, it was I thought, ethical as well as professional duty to ascertain whether my client was being damaged by his behavior. So as these came in, to my astonishment, we kept getting more and more and more. And as we got more and more, I caused supplementations and amendments to be addressed, frankly, hoping that when filed with prior counsel, and then ultimately when you came on board, that Mr. Clark would get the message that he needs to stop.
Okay, so we've just learned something very important. So the couple at the top, Mr. Clark, Christopher Clark, with the striped blue background, and the lovely lady next to him, Christina Clark. This is some type of an enforcement action regarding child custody, or it's something with their family law divorce case. I don't know whether the divorce is finished or not, but this has to do with violations that are being alleged against Mr. Clark. Lopez is Christopher Clark's attorney, along with someone named Torres, who might be under the comments. I don't know. I don't see another Torres. Mr. Ullman is Christina Clark's attorney. Now, I don't know what these two do for work, but if either one of them can afford $100,000 attorney's fees, we're dealing with some very wealthy family law individuals, and they can get petty. They're the worst.
Non-responsive.
Sustained.
I think I hear what you're saying is that work was performed, but in order to have the court order that you are entitled to those fees, you have to prove those violations, don't you?
Have to prove the violations that we are alleging in this hearing, yes.
Okay. And the attorney's fees that you're requesting have to relate to the violations, don't they?
They have to relate to the violations and the history of how we acquired those violations and processed them and pled and prepared for hearings, yes.
But the important thing is that you have to prove those violations, don't you?
Correct.
And in order to prove a violation, you have to pursue it, don't you?
Correct.
And you are pursuing less than 10% of the violations that you alleged?
Numerically, yes.
Thank you. And again, just to be clear, you take no position on whether Mr. Clark had to spend any attorney's fees having to defend this case or not.
I'm guessing that he has spent money. I do not
I don't
know.
want you to guess, Mr. Ullman. Just if you have an opinion, if you don't think that he did, say so. If you,
If he
I-
doesn't know, he doesn't have to.
I don't.
that's exactly what I'm saying. If he doesn't know, if he can't make an educated guess,
He's already said that.
okay. What remedy are you and your client seeking today?
The remedy we're seeking is confinement in jail and curative relief that he be ordered to repay the sum, and it's set forth specifically in my pleadings. And in a requested relief, it's about $425,000 that he failed to timely disclose per this court's order and before an agreed injunction. And of course, attorney's fees and expert fees.
How long would you like Mr. Clark to be incarcerated for?
Well, I had hoped that we could have concluded.
Objection non-responsive.
Oh, no,
Objection non-responsive. I asked
Sir,
for.
you asked him if what he thought was appropriate. I think that's what he's trying to say.
We're asked.
Your Honor, hold on, Your Honor. This case goes off the rails because one question's asked and several opinions that are unrelated go on. I asked for what length of time, not why do you think one length of time at a prior period of time, and why are you asking for something different now? He can clean that up later if he wants to. I had a direct question. How long should he go to jail for? That's the question that's before the court.
Well, he can give his opinion to that.
How long should Mr. Clark be incarcerated for on your motion for enforcement?
I believe he should be incarcerated at a minimum each weekend until the trial date, from Friday at noon until Monday morning.
And how many days is that?
I don't have the counter in front of me. I'd have calculated.
Does Aransas County do weekend jail?
I have no personal knowledge.
So why would you ask for that if you don't know whether the Aransas County even does it?
Because I have never seen a county court that doesn't incarcerate people on weekends. That's my opinion, my observation.
You didn't spend any of that 101,000 researching on whether that was a remedy that was even available to you?
No.
Okay. And if currently Mr. Clark is paying for all of the legal expenses in this case, isn't he?
No.
Okay. Who else is paying for legal expenses in this case?
The community estate.
Okay. Thank you. Is there somebody other than Mr. or Mrs. Clark that's paying attorney's fees in this case?
Someone other than Mr. No.
Okay. And in fact, you had told the court that you had a fairly significant balance and Mr. Clark paid $100,000 towards that balance. Is that correct?
Yes.
And how much does Ms. Clark currently owe you?
I've got that somewhere. Okay. The current outstanding invoiced balance to me personally is $76,321.19. The time that's been.
Objection, non-responsive. I
No.
just need the dollar amount. I didn't ask about time.
The total amount that is billed and is not in the amount that has not been invoiced.
$76,321.
No, it's $182,373.69.
That's the total amount of work that has been billed to Ms. Clark.
That's the total.
That she has not paid.
That's the total amount that has been billed and has not been billed yet, because I have not had time to invoice her for some of the time. But that's the amount of time that's been incurred between me and a minority amount of that amount, $16,088.50 is Mr. Trends.
When was the $100,000 received from Mr. Clark?
Which 100,000, what did the last payment that he made?
Yes, Mr. Ullman, the most recent.
That was about, what was that, 4 weeks ago, approximately? I think.
And has that been credited to Ms. Clark?
Well, first of all, your client insisted on a credit
Objection,
card.
non-responsive.
I did not receive $100,000 from Mr. Clark.
Did you receive a $100,000 transaction to your account from an Amex payment made by Mr. Clark?
No,
You're saying no because your Amex processing account requires you to pay processing fees, right?
yes,
You have an agreement with Amex to pay processing fees.
I do not.
Okay. Somebody who processed a credit card for you, you have an agreement with to pay their processing fees, don't you?
Apparently, yes, if I can tell you what happened, I'll be happy to answer the question.
Mr. Clark had no say-so over who you choose to do your credit card processing, does he?
I asked for a bank
Objection,
transfer,
non-responsive.
if I may, Your Honor.
Objection, non-responsive.
Well, you have to answer his question. Does his client have any say-so over your credit card business?
Mr. Clark insisted on paying with.
Objection, non-responsive. My goodness, Your Honor.
Well, both of you are very difficult in your questioning and answering and are slowing this thing down. Just
Well, I haven't
answer the
testified
question
yet,
directly.
Judge. No one's asked me any
I'm going to
questions.
answer the question directly, please.
My QuickBooks transfer, the transfer from Mr. Clark's card to
Paul,
my
he didn't ask you that, sir. He asked you if Mr. Clark had any control over who you used as a credit card company.
No,
When Mr. Clark swiped his card, he swiped it for 100,000, correct?
I think so, yes.
Okay. When it hit your account, it was something different based on an agreement that you have with QuickBooks or somebody else.
Yes,
Okay. The amount that you did receive, my guess is it's a little bit less by maybe 3%. Is that about somewhere in that range?
I think so, yes.
Okay. Did the amount that you did receive, was that credited to Ms. Clark?
Yes,
Okay. And this $182,000 balance, that is reflective
Lopez isn't just badgering the witness, he's badgering the judge too.
of her balance after the 100,000 minus 3% was credited to her account?
yes.
How much attorney's fees have been incurred from Ms. Clark in the last 30 days?
I don't know. I'd have my paralegal maybe could process that. I don't have the answer for that.
I asked you on the 26th on what the likely value of this estate was, and you weren't really sure what it was. Is that correct?
That's correct.
You would agree with me that as attorneys pursuing claims for our clients, sometimes we have to make a judgment on whether the claims that we're pursuing are actually going to justify the cost in pursuing them. Would you agree with me?
Yes.
How do you know that spending $101,000 on one motion is reasonable and necessary related to the amount of the arrest of the estate if you don't even know what the arrest of the estate is worth?
That is not how I determined. I mean, I did take that into consideration in the background, even though I'm unsure of the value because of some of the activities. But what I was taking into consideration primarily was the amount of damage that was being done to the estate and to my client and to her children, frankly.
Well, you have pursued claims on her behalf for fraud and reimbursement and disproportionate share of the marital estate. Is that correct?
Yes.
And the $425,000 that you claim was spent either frivolously or fraudulently, that likely makes up a percentage of the estate, just a portion of the estate, correct?
Yes.
And with the claims that you have pursued for fraud and waste and disproportionate share, could not that $425,000 been addressed at the final trial as a line item under a waste claim on a spreadsheet?
It could be, but it doesn't. It could be. That is another way of requesting relief. Yes.
And in fact, you've already done that, haven't you?
Yes.
And so the facts that you would be presenting in order to prove those claims of fraud, waste, and all of that, that you would be doing at trial, we're sort of doing in advance now here with this motion for enforcement. Is that correct?
And disagree.
Disagree. Okay. What you are demonstrating to the court is that, or what you are attempting to demonstrate to the court in this motion for enforcement is that Mr. Clark has wrongfully spent money for his own personal entertainment or enjoyment to the detriment of the community. Is that right? And in violation of the standing and other temporary orders.
In certain of the violations, that is correct.
Okay. Other than incarceration and attorney's fees, what does an order on an enforcement do for Ms. Clark?
What's the benefit to my client? Is
Yes,
that your question?
right.
Well,
What is the $101,000 benefit that this motion is conferring upon her?
well, if you look at my pleadings, let's see, I can tell you more specifically.
I'll withdraw that question.
Okay.
Ms. Clark has spent $101,000 and probably now more, now that you've been billing her for the last 30 days, correct?
There's somewhat more, yes.
Okay. You're not sure, but you guess that Mr. Clark might have also spent some attorney's fees appearing in court and defending this motion for enforcement, right?
Well, we know you're not working for free, Mr. Lopez.
Correct.
Now, the source of the $100,000 in attorney's fees that you want would effectively come from monies that were earned by the community, particularly by Mr. Clark, correct?
I don't know what the source would be, whether it be separate or community. I don't know where he would.
Okay,
get the
what
funds
is
from.
Mr. Clark's separate property?
He alleges that a separate property, at least in the past, is CPC interests. He alleges that his, I think it's 66 acres of the homestead property is his separate. He alleges that he has a separate property interest in the Wyoming ranch. That's a generalization of what he's alleged.
And you agree with me, Mr. Ullman, that all property that is before the court is presumed community property until proven otherwise by clear and convincing evidence?
Yes.
Okay, so at least where we stand now procedurally, the 101 would come from the community, correct?
Presumptively, yes.
Okay, and until a presumption is defeated, it's the presumption of the court, correct?
Yes.
Okay, so the 101,000 would come from the community, right?
Presumptively, yes.
And it would go into your pocket, correct?
Yes.
Okay, and the $425,000 that you want the community to gather, or Mr. Clark to gather from the community, would go to the community?
No, to the registry of the court.
And what purpose would that serve?
It's to preserve it.
Okay. Mr. Clark, Mr. Ullman, how much have you received in attorney's fees in this case?
I don't have that before me at this point.
Is it too much to count?
It's objection to relevance to this motion, Your Honor.
Your Honor, I want to know what portion of the work Mr. Ullman has done for Ms. Clark over the last year and a half has been related to this motion that we believe is excessive.
And you're going to get there by making childish remarks like, is it too much to count? That's not a serious question, sir. And I'm pretty sure the judge doesn't like it.
And depletes the community rather than protects it. And so we want to know if he's been spinning his wheels doing mostly this, because that's what it appears to be thus far.
Well, I think he's just said he didn't know.
And then my follow-up question to that was, is it so much that he can't count it?
which seems like an irrelevant question to me.
Mr. Ullman, you've been critical of Ms. Torres and I receiving $150,000 each for our representation in this case. Do you recall that?
I've never criticized the amount. I was surprised at the amount. I didn't criticize it.
What's surprising about the amount?
Because of the amount of money that had already been spent by prior counsel, and you guys came in, and and on top of what had been done was an additional 300,000. I was surprised.
How much had prior counsel charged?
It was in the hundreds of thousands. I don't recall specifically. I'd done calculations from time to time, had my paralegal do that, but I can't tell you I recall that at this time.
You know what your opposing attorneys charge generally, but you can't tell the court what you have charged in this case?
Mr. Lopez, what's the value of that question?
It's pointing out that Mr. Ullman only answers the questions that he wants to and that benefit his client, and not the ones that question the argument that he's attempting to make.
It serves no value whatsoever in this motion. Move on, please.
Thank you. Your Honor, I'm reviewing my notes. Just give me a moment. Mr. Ullman, before narrowing down to the 56 violations, did you happen to reach out to Ms. Torres and I and ask if we could review those violations together?
No.
And in fact, after you received some supplemental discovery from us, you had to drop some violations because you were incorrect when you alleged them, weren't you?
On some of the violations?
Yes.
Yes, there were some, as I referenced earlier, some typos, I believe.
Don't you think that before we have a 4-day, $100,000 trial, that maybe sitting down and trying to talk through some of these expenditures would have been something that a prudent attorney might have done?
I don't recall you guys reaching out to do that either, counsel.
Okay. So, okay, that's fine. You took Ms. Dee Dee Floyd's deposition, didn't you?
Yes.
And she told you all about the tax benefits of purchasing of cattle and the tax reduction strategies that were used by the Clarks and CPC during her deposition, didn't she?
No.
Are you saying that you didn't ask her about purchase of cattle as a tax reduction strategy?
I don't recall ever asking her a question about purchasing cattle for a tax deduction strategy. I don't
Mr.
recall.
Roman, you may not have asked her the question, but she might still have testified about that.
I thought you asked me if I asked her questions about it.
No, I asked her whether you took her deposition and whether she testified about that.
I don't recall that being your question, but I recall her mentioning discussing cattle, the longhorn cattle purchases, and that we're suffering losses, and thus you could deduct losses. I recall her mentioning that, yes.
Why do I have to ask you? Why do I have to go around the question so many times in order to get a direct answer from you, Mr. Holman? What do I have to
That's not a legitimate question.
It's cross-examination, Your Honor. He's a witness.
Yeah, and so ask him a question about the facts of the case.
Well, I also get to ask him about his credibility, Your Honor, and when he's got foggy memory on the question worded one way, and then he understands it exactly when I worded another way. I want to know why. Is it me? Do I not ask good questions? What is it about those questions that I have to ask him multiple times to get a direct answer?
Well, sometimes he's not giving you a direct answer. Sometimes it's the way you ask the question.
Well, and that's what I'm asking, Your Honor, is it something about why is it that I have to ask so many questions to get to a very obvious answer?
Well, I don't think there's a possible way to give an answer to that makes any sense of value to this hearing.
Well, Your Honor, I'd like to streamline this, and if I can try, if Mr. Ullman tells me he doesn't understand the way I speak or like the way I speak, if he could just tell me that way I know how to ask direct questions and get direct answers.
Mr. Ullman, in the future, if you don't understand a question, please say so at the beginning and rather than launching into a multi-point explanation when you're not sure what the question is.
Yes, sir.
Your expert described some of the charges that you are pursuing as particularly egregious as they relate to an out-of-state trip to some theme parks. Do you recall that?
Yes.
You recall some of those violations were for some were for less than $100. I think one of them was for $77.
Yes.
How much attorney time did you spend on that $77 violation?
It was not, we didn't keep time per violation in that sense because
Well, isn't that what Roar Moose requires?
I'm sorry, say it again.
Isn't that what the Roar Moose case requires?
No,
Okay. So what you're saying, your opinion is that Roar Moose allows you to bulk bill?
I'm sorry. Could you speak up, Mr. Lopez?
Is it your position that the Roar Moose case allows attorneys to bulk bill?
No,
Okay. But you do not know how much attorney time was spent on the $77 violation.
again, I refer to the specific time entries that associate those with the pleadings. And when you're preparing for a hearing,
Objection non-responsive.
no, it does. I don't have it isolated in my recollection as to each violation. No.
You would agree with me that spending any more than $77 on a $77 violation is not a wise use of community funds.
I would disagree with that.
Okay. And so how much would be a reasonable amount to spend on a $77 violation?
How about you not focus on how much it costs to defend the violation, and you focus on instructing your client not to violate? I mean, this is almost lawyer victim blaming. You don't have a right to charge what you charged defending your client against my client's shitty behavior. Don't worry about what it costs to defend it. Worry about telling your client not to do it, because they're going to get into what he did in just a minute here.
My answer is that we were trying that
Objection
77.
non-responsive.
No, here my answer is that $77 was not isolated. When we found it, there were
Objection
multiple.
non-responsive.
Overruled.
When we found, yes, thank you. When we found those, the trip information, there were multiple violations. And that was pointed out by our expert. It was not each single violation that was egregious. It was a fact. It was the pattern, multiple violation, multiple purchases, the tickets, the hotel stay. We simply included the $77 one along with ones that were $1,000 or more or less. But in the accumulation of that one trip, my recollection is it was something close to $7,000. I don't recall exactly, but it seems it was thousands of dollars, of which the 77 was a portion. So the time spent on that was probably minimal. But when you add it amongst the group of the categories of travel and entertainment that we reduced it to, those were impactful. That's 7,000, and it was egregious because of the outright defiance of the restraint in place by the standing orders. That's why we pled it.
Okay. How much attorney's fees and expert time were put into pursuing the entire Florida trip, the $7,700?
It's in my pleadings and in my timesheets. I have not taken the time because I did not know you were going to ask that type of inquiry.
And so you don't know, as you're sitting here before the court today, on whether you spent double, triple, or even 5 times that amount on pursuing the violations, do you?
Which violations?
Mr. Ullman, the ones we're talking about.
The entertainment violations? Disney World?
The Florida trip, the incident we've been talking about for the last few minutes, Mr. Ullman.
Okay, they are in my records. I would have to take time to,
Objection non-responsive.
I can't answer that question.
You don't know whether you spent double that amount, triple that amount, or even 5 times that amount pursuing the violation, do you?
It's all reflected in B23.
Objection non-responsive.
Overruled.
Okay, and what is that amount? If it's in your exhibit, I'm happy to wait.
I did not anticipate your questions. I did not do the math.
That's okay, I can wait.
I don't know how long it's going to take me to answer that question, Mr.
And we're not going to sit here and do math calculations at this point. He said he doesn't know, so he doesn't know.
Then I'd like to strike his testimony on anything that he states he does not know and have any personal knowledge on. If he does not know the amount of his attorney's fees or the amount that was prepared or that was incurred to prepare for each violation or to pursue each violation, his request for attorney's fees should be struck, or he should be compelled to answer the questions.
The request is denied.
The request to strike his testimony, or the request to require him to review his documents and answer truthfully?
Well, the request to strike is definitely denied. The other portion is also denied. There was no, we're not going to sit here and do math.
But if the witness isn't prepared to answer questions on a request that they're making, Your Honor, then that request should be denied.
Well, but his,
Because we're only on violation 2. I've got 998 more to go, Your Honor.
well, you and I are having this discussion as a courtesy. You don't get to question me about the law and what the reasons for my rulings are. But I will tell you in this instance, and what is making this hearing so difficult is you're insisting on him answering questions that he has answered already in one or more different ways. And to continually ask him about his answer as to the specific amount attributable to each category does not mean that he is required under the law to prepare it that way.
I agree that he does not need to prepare a pleading that way, Your Honor, but in order to prove that if attorney's fees are reasonable and necessary, what it should say is violation number 1, or what you should prove is violate, and I'll take it outside of the spending context and put it into maybe a parent-child context. Violation 1, I was at the exchange location at 6 p.m. Dad did not show with the child. I had to pay my attorney's fees, $500 to write a letter, $500 to write a motion, $600 to appear in court, not the other $1,800 I had to file because he didn't, or that I incurred because he didn't pay child support on time. That's essentially where we're at, is that he says, hey, he did a bunch of stuff that he shouldn't have done, 1,000 violations, but I'm only going to be asking the court to consider 56. So if they don't consider the other 940, they're not pursuing them, they don't get attorney's fees for those. So if they're saying 101,000 covers the entire 1,000, they need to tell us which individual violations correspond to which individual charges, because the court might find that spending an hour on one violation is reasonable and necessary, but not on 3. But when they're asking for 4 hours worth of attorney's fees to be awarded to them, then they're getting the benefit of allegations that they don't even prove or attempt to prove. Now, if Mr. Ullman had done all this work to narrow it down to 56, he should have done what we all do when we have our hybrid attorney's fees invoices. This is what I spent on the modification. This is what I spent on the enforcement. What he should have said is, hey, I did a lot of work on this enforcement, $100,000. I'm only pursuing 56 violations. These are the charges that are actually related to what I'm proving to the court, or what I'm suggesting to the court I'm allowed reimbursement for. But now with the 1,000 counts in front of the court, with Mr. Ullman refusing to non-suit the other 940, still asking for attorney's fees on the other 940, and with the court not granting our motion to dismiss those with prejudice, then we have to go through each violation and defend on each violation. I don't know if Your Honor is going to put my client in jail and on for what violation and for what period or duration. I have to defend him tooth and nail because that's what he's facing. He's facing a loss of over $500,000 in this case, as well as personal freedom. And I don't have to tell the court that him being in jail is going to put a significant strain on his ability to both earn as well as prepare for this trial that's upcoming. So we have to do it this way, unless Mr. Ullman will just cut to the chase of what it is that he's actually asking for and what the violations, what the attorney's fees justify.
Okay, I've let you have your say. I think we've crossed the line as to what's appropriate between an attorney and the judge in hearings such as this. And so I'm going to pass it back to you asking questions of the witness, and hopefully we can get down the road somewhere.
It's no secret that there's been a sort of swap of dating partners in this case, correct?
Objection, relevance.
Okay, do you know who it was that the Florida trip was primarily for?
No.
You didn't know whether any children went on that trip? You think Mr. Clark went to Disneyland by himself?
My recollection is, no. You said who primarily, and I have no clue who primarily was benefit. If the question is who was on that trip, I recall Mr. Clark, I recall Lauren Self, and I recall, I think she has 2 children. I think they were on the trip. And I don't recall specifically if there were others on that trip or not.
Do you know if those children have any kind of relationship with Miss Clark, the children that went to Disney?
The Selfs or what?
The children
what
that went to Disney, the ones that went to Disney, the ones that went to Florida.
Objection, relevance.
Overruled.
As I've said, my recollection is that Mr. Clark, Ms. Self, 2 children.
Objection non-responsive. Mr. Ullman, the question was whether those children have any relationship with Ms. Clark. The children I'm referring to are the ones that went to the trip. The trip I'm referring to is the one to Disney in Florida.
Which children are you referring to?
Your Honor, I don't think the witness.
I don't understand. I don't
Objection
understand.
non-responsive.
I don't understand the question. When you say the children, what children are you asking me about?
The children that went on the trip to Florida that you have filed a motion for enforcement regarding.
Which children are you asking me have a relationship with my client?
The ones that went on that trip, Mr. Ullman.
I know 2 of them. The Self children likely have no relationship with my client.
Likely have no relationship.
I have no knowledge that they have any relationship with my
That's all I
client.
was asking. Thank you, sir. Thank you. And so it would be news to you if those children that went on that trip have been effectively positioned to be Miss Clark's new stepchildren. That'd be news to you.
I mean, there's still, Miss Clark is still married to Mr. Clark. I'm not.
Objection non-responsive.
I don't know
Objection. Okay.
about them being stepchildren.
Objection is overruled. Non-responsive is overruled. If you want to ask him about specific children, ask him.
Sure.
He's told you what he knows.
Thank you, Judge. When you had cross-examined Mr. Clark about all of the violations as you have alleged, did he deny spending any of that money?
He did not deny spending the money, correct?
So really the dispute here is not so much on whether he's hiding or secreting money, but rather he's spending it in a way that he felt would be okay with the temporary orders and standing orders to your disagreement.
I have no idea what's in Mr. Clark's mind. I filed the motion because I felt they were a violation of the court orders.
Okay. And in doing that, you conducted no investigation as to who the children were that went on this egregious trip, the $7,700 trip?
No, we have tickets. I know, I disagree with that statement.
And none of that $101,000, did it occur to you to say, maybe I should check and see who went on that trip?
I do know who went on that trip.
Okay. And who was that?
Well, I know that he spent money on his girlfriend and on her 2 children.
Okay. And who are those 2 children?
I don't recall their first names.
And do you know whether they, no, you don't know whether they have any relationship with Miss Clark, right?
I do not, correct.
You don't know if they've ever met. You don't know if they spend time together, nothing like that.
Frankly, I don't have any personal knowledge of it that I can recall.
Okay.
None that I know of is my answer.
Your Honor, pass witness.
Judge, I have hopefully very short redirect, and I'll be finished. We began receiving financials finally on January 16th of 2026. And between January 16th of 2026 and 4/26, 3 months, we received 14 different tranches of documents. We had to analyze all of those to determine if they were what was going on financially. And in doing that, we found what we believe to be 970 credible violations. We, as counsel, had to reduce the number that we were going to prosecute because we became aware of the court's docket, and even this court, as I recall, enunciated at some point that there wasn't going to be time to hear 1,000 or words to that effect violations, and so we had the violations listed, frankly, as an attempt to curtail Mr. Clark's behavior, which wasn't effective. Now, as to the issue of of narrowing the fees only to the 56, that is a description of what we had to do. We had to sort through all these to ultimately reduce them to the 56 that we felt were exemplary of the behavior of Mr. Clark. If we were to prosecute the remaining 900 or so violations, the fees in this case would go up exponentially. We'd be here another 4 or 5 days. So in an effort to keep the fees as reasonable as they are, we are not prosecuting those. But can you only imagine if I asked Mr. Clark about the remaining 900 instead of the 56 or 60 that I questioned him about, we would be in court for a week, 2 weeks. It was reasonable and necessary as we found these violations to file the original motion, amended, supplements, kept sending them to counsel, hoping it would stop, and it did not. And the fees are reasonable and necessary because under the the contempts 1 through 6, there are violations that total $417,429.34. And those are 51 counts. Then in addition, there's counts that arise under the contempt violation, which is contempt 7, I believe. And those are totaled along with, I think, the violations under 7 were approximately $903,564. That's the $425,000 that was not reported, and the $425,000 approximately that was then spent. in violation of the court, because at that time, Mr. Clark was supposed to be getting permission for expenditures exceeding 500 and then later 1,000.
Oh, that's a lot of violations. That's a lot of him trying to stick it to her, or sneak one in like no one's gonna notice. He didn't think you'd get caught. And you know darn well he has been manipulating Uncle Sam for a whole lot of years with that money.
Your Honor, we're going to object to just the narrative response starting to sound like closing argument.
How else is he going to do it?
At closing argument, Your Honor.
I'm testifying as a reasonable and necessity, and I will be finished in less than 2 minutes, Judge, on this, if I may.
I'm going to let him continue.
So in my opinion, the $101,160.86 in attorney's fees, as well as the $42,112.24 in fees, only represents about 16% of the close to $1.5 million in violations, and counts 56 counts. So relative to that, it is not disproportionate. And if you recall, and you may not because you weren't in the case, but our original motion and our subsequent motions, or at least original motion, also alleged that Mr. Clark had not timely paid medical reimbursement and tuition.
Your Honor, none of this is redirect. None of this was brought up during cross-examination, or excuse the next portion of his testimony Mr. Ullman was getting into about medical and parent-child issues.
Judge, my response is it is relevant to the issue of reasonableness and necessity of all the actions that are described in my Exhibit P23. And I will be finished in less than a minute.
Well, he is correct in that it should be limited to what's in your contempt motion, not things outside the contempt motion. So you've got a minute to wrap it up.
Right. I was just simply pointing out that the actions that we took were reasonable and necessary, notwithstanding the fact that Mr. Clark did cure his failure to timely medically reimburse, and the fact that Mr. Clark timely cured after our motion.
Same objection, Your Honor.
Okay.
Sustained.
I have no further testimony, Your Honor.
All right. What else do we need to get to today?
Well, Mr. Clark's defense, Your Honor.
Don't we have an issue about a real estate agent?
Ms. Torres was handling that with Mr. Ullman. I can ask her to step in on that.
We have an agreement, Your Honor, and if we have not already circulated an order, we will do so this week.
Who's your choice?
We agreed to Eric Blunzer, Your Honor.
Is that correct, Mr. Ullman?
Yes, it is. And I'll be happy to discuss that if Ms. Torres is handling that. There are other issues, Judge, specific terms that we need to discuss to provide to Mr. Blunzer. You know, the court stated some parameters in an earlier hearing about no listing, I think less than 90%, et cetera. But I will attempt to see if we can resolve those term issues. And if not, I think we return to the court. And also one other thing that I need to discuss with Ms. Torres that should be included, I think, is the exact acreage. We've discussed, there's three different parcels, and there's actually 4 different parcels. And I'm unclear as to whether or not we're asking Mr. Blunzer to sell all 4 parcels or a portion thereof, and we need to discuss that. I think my client's position is we should sell all 4, but I'll discuss that with Ms. Torres and see if we can resolve that between us.
And Your Honor, we will need to discuss that because there is a portion of that land that is separate property. So, but I will get with Mr. Ullman after this hearing. And if we cannot come to a resolution, Your Honor, then we'd ask the court to add this motion to our next court setting which I believe is on July 23rd, Your Honor. In fact, it's listed, the Realtor's motions are already listed on, oh, I take it back. That's June 23rd. It looks like our next setting judge is July 30th.
If you're gonna add something, you need to contact Ms. Edwards and work that out with her so that it's in writing and we keep track of it.
Yes, Your Honor.
And we also had our motion for enforcement as well that has not been heard.
Right. And anything else?
Yes, Your Honor, the petitioner has had a motion, we filed a motion to modify an order on valuation of marital property. You may recall, Judge, at a prior hearing, we discussed the party's desire to value personal property, and the court signed an order ordering us to exchange lists of property we wanted to examine. I think it was supposed to be produced by June 10th, or excuse me, June 15th. We have sent the list timely to council. We have sent the proposed evaluator that is going to look at the personal property, artwork, etc. We were informed that that Mr. Clark was in Europe till July 12th, and that we could not meet the deadline of July 10th, which is in the court's order. So we're asking the court to extend the date that we can examine the personal property that we sent to council, that be extended to beginning July 13th, that Mr. Clark produce the personal property, and that we have the ability to look at that property from 8 to 5 from day to day as necessary, and to have access to the CPC office to examine the property, which is also in the order, because Mr. Clark's not available till he gets back.
Your Honor, if I may, I am aware that Mr. Ullman had some difficulties there and had filed a motion. We have not gotten to work with Mr. Clark on that yet. I anticipate that we'll be able to reach an agreement on everything that Mr. Ullman had mentioned, but we're not prepared to respond to that motion or go forward on it today. But I'm happy to confer with Mr. Ullman on that.
Yeah, Judge,
In fact, Mr. Clark skipped to Europe during the period in which he was obligated to respond to that order. Is that correct?
I don't know.
No, Your Honor, when last time that we were in court in late May, early June, we advised the court of Mr. Clark's vacation, my vacation, and Mr. Lopez's vacation. So the court was made aware that he was going to be gone for quite a number of days, and the court gave him approval to appear by Zoom.
I do recall that.
but that still,
But
Judge, Mr. Clark doesn't have to be present when we inspect it, but they are insisting that he does that. So that's why we're asking for this extension from the 13th and the following days. I can't count on an agreement with Mr. Clark, Your Honor. I would like the court to, respectfully, I request the court to extend our examination and order that Mr. Clark or his designated person produce the property in our list that we timely produced, and that we have access on a July 13th and from day to day as necessary.
Your Honor, like I mentioned earlier, I anticipate being able to work that out with Mr. Ullman, but if he's asking for a court order, that does require a properly filed and set motion with proper notice to all parties, which we don't have at this time.
Yeah.
I would love to have answered a call from Mr. Ullman yesterday. He has my cell phone number. He's called me plenty of times on it throughout the duration of this case.
Yeah.
But I just have not had a chance to discuss that with him, and I would appreciate that opportunity from Your Honor.
Your Honor, all due respect, there is a petition on file. It is set, and we have correspondence to both counsel attempting to get to the property, and we're informed by staff at Ms. Torres's office specifically that she was on vacation herself and could not respond until after the 10th, which is after the deadline date.
Right, and Ms. Torres and I both have vacation letters on file, and under the Texas Lawyers Creed and under just common courtesy, most attorneys do not send discovery requests, file motions that require preparation and response, set hearings without conferring, or doing things like that during vacation. So again, I'm happy to give Mr. Ullman a setting if that's what's necessary, but just an opportunity to talk with him first. He didn't pick up the phone and call
When can
me.
that occur, Mr. Lopez?
Um,
How about right now?
prepare for, get 3 days notice right now, prepare for a motion, discuss it with my client, come up with a response, and then negotiate it with Mr. Ullman. That should only
Judge,
take
I
7 to 8
have the
hours.
motion. I have the motion. We have conferred. We sent correspondence.
I
I'm
don't
not,
think we got a notice of setting from the court or notice of court proceeding. Maybe Miss Edwards can let us know.
No, I'm not saying have the hearing right now. I'm saying it's 3:20. I have no doubt that we could not complete another motion today. Why not take this time for you two to sit down or Zoom with each other? You're already here to try to work this out as you're suggesting.
Certainly.
And Your Honor, we do have a Zoom meeting, Mr. Lopez, Mr. Clark, and myself at 4. So maybe if the court gives us till tomorrow at 5 to work with Mr. Ullman, that'll give us an opportunity to speak to Mr. Clark about the issue at hand. But I've not seen anything or read anything that Mr. Ullman has sent over.
it is, it was the judge, you signed an order setting this for hearing on June 5th. They are on notice of this. This is another delay, Your Honor. I filed a motion.
Well, I'm trying
not
to get
trying
you
to-
what you're asking for. You're asking for an extension,
Yes.
and I'm willing to grant that under certain terms. But
Okay.
I'm trying to give y'all an opportunity in the immediate to work that out as to realistically, it doesn't do any good for me to issue an order that's impossible to comply with. And I'm trying to give you, now they're saying 5 o'clock tomorrow. Is that too late?
It's not too late, but assuming we can reach an agreement that, because we have talked to our expert who has a schedule of his own.
Forget the breakout room. Get him one of those shirts that's like oversized and put both of them in it. The get along shirt. Then stuff them in a closet until they've worked out all of their differences.
He has said this will work. He was going to be there before the 10th, but because we were notified Mr. Clark was not going to be there, so we couldn't do it, which was not presented at the time that this order was signed. They did not say the property would be unavailable to be inspected. We're finding this out this last week or two. So I'm being patient and I'm happy to work it out, but I'm not optimistic. And if we can't work it out, when do we have a hearing?
Why don't we do it this way? Why don't we do it? Hang on 1 second. Why don't by agreement, try to give everybody part of what they're asking for. We can give y'all till 4 o'clock tomorrow, and at 4 o'clock, y'all can call into the court on a Zoom and tell me the points that have worked out, and the points that haven't been, I'll resolve.
Okay.
I think it works with that. I just need to confirm with Ms. Torres that she can handle that if for some reason I'm not able to. I'm still on vacation and kind of at the mercy of what our plans are.
And
That's fine with me, Judge.
I'm in Rockport tomorrow, so I may just go on into your court. But I'll be in front of Judge Bauer tomorrow all day. So I can always
Well, there's no sense in trying to coordinate with Judge Bauer on when she's going to be finished.
But I
You
mean,
have some reason to think you'll be finished in the morning, or?
I don't know, Judge. It's a civil case that is set for apparently on her docket for next Monday, and we are number 1. So I don't know how long it's going to take to argue some motions that are going to go forward tomorrow. But worst case scenario, I will ask her for 5-10 minutes to slip out of her courtroom at 4 o'clock.
Well,
Or I can let you know.
that's not going to work. Mr. Lopez is not going to be there, and you're not going to be available till 10 minutes to 4 is what you're saying. That doesn't make any sense. That's not even a valid offer? When were you going to discuss it with Mr. Ullman?
Well, my plan was, we're gonna meet with Mr. Clark at 4 o'clock, and then hopefully we can come to some terms that Mr. Clark and Mr. Lopez and myself can agree to, and then call Mr. Ullman tomorrow morning.
I would like to get Mr. Ullman's proposal, if he wants to send it to us in writing, that way I can forward it to Mr.
It's not
Clark.
his proposal, it's mine.
Oh, okay. I'm sorry. I would like to hear from Mr. Ullman exactly what he needs to get started on the 13th moving forward. And if that works out, I might be able just to send him a text message later tonight, letting him know that we got that worked out, but we need some private time with Mr. Clark in order to do that.
And that's arranged at 4 o'clock this afternoon?
Yes, Your Honor, my office has already sent a Zoom link for us to meet when we're done here.
Well, then why don't we take the next few minutes to bullet point out the points that Mr. Ullman has stated so that you can discuss those with Mr. Clark, and we can in fact get a response from you.
Great, Your Honor.
Does the court want to put us in a breakout room with Mr. Ullman?
Mr. Ullman, are you in on all this?
Yes,
All right.
I just want a practical solution.
Well, and that's what I'm trying to dig too for, and sometimes they're hard to get to. All right, let me go get.
And for purposes of their discussion, Judge, I've stated what our request is. We want to have access by 8 o'clock on July 13th. And there's hundreds of pieces of personal property on our list, so we want to have access July 13th and subsequent days from 8 to 5.
This
That's
is what I'm
that's
trying to avoid, Your Honor, because by him giving you his whole life story of his motion, then in a sense, he's arguing the motion to you right now. And so that's why I'm saying, put us in a breakout room and he can make this argument to Steve and myself instead of going again and making this argument to you. And then we have to respond in order to cover our bases. And now we've wasted the court's time and we're at 5 o'clock.
It's not my time that I worry about. It's trying to make sense out of a legal proceeding, which seems to have escaped us. But I don't know. I don't have much faith in this, frankly. I thought we were going to get somewhere, but now that we're talking about Mr. Clark having to agree to it, he's just not going to do that.
I disagree, Your Honor. I think we just need to check with him on what times work for him, what times don't work for him, what portions of
I'm worried about the continuous 8 a.m. for as many days as they need. Y'all might be better setting a certain number of days or specific times for X days. And if that doesn't work, then we regroup. But I'll leave that to y'all. Hang on, and I'm going to get y'all into a group.
And I just wanted to confirm on the group, it's just the attorneys, just Mr. Ullman, Mr. Lopez, and Ms. Torres. Is that correct?
Yes.
Yes.
Okay. All right. I'm going to open the room and just, I don't remember, you'd have to click on something.
Because I don't have any of my paralegals on the Zoom, so just the lawyers.
Okay.
All right. Good luck.
I see that you're back, Mr. Lopez, but no one else is. Were you just needing to check in on something?
Oh, no, we're done talking.
Okay. I'll close the room then.
Thank you.
It'll take up to 60 seconds for everyone to come back.
All right. Our happy group is back.
We're back, Judge.
Didn't get it done?
We got very close.
Really?
We did. Well, I don't know how much the court wants to get into our discussions.
I don't need to be into your negotiations. What we were going to do was, as I understood the agreement, was that y'all were going to try to get it done. And if you couldn't, then I would dictate the rest of the terms as part of the extension.
We did try to agree. We did come up with some dates that I do think that work. There's a term that we need Mr. Ullman and Ms. Clark to agree to. They won't. And so I guess we have to do everything the hard way.
Judge, if I may, Well, I won't discuss our attempt to resolve it. My request remains the same. I want at least July 13th and 14th. And I'll be happy to, if we fail to have ample time at that point, or there's personal property missing, I will take that up with counsel and try and resolve that. Failing our ability to resolve that, I'll alert the court through a motion.
Your Honor, respectfully, we would ask the court to not take any action on the motion today. I have not seen any notice of setting. I haven't read Mr. Ullman's motion. I did get served with it. I'll remind the court that I am on vacation. I do have my vacation letter on file. Same with Ms. Torres. We were prepared to move forward on the enforcement that we agreed to come in on during our vacations. My understanding is that there was an order setting a hearing for Mr. Ullman's motion that was signed on July 1st. You know, there's been a Saturday, Sunday federal holiday in the meantime, and we're just not ready for it. So I was hoping that we could work it out. But again, there's some terms that some folks aren't willing to agree to reach an agreement. So we're going to have to do it the hard way, like I mentioned. So we would respectfully request a setting.
That motion was not set for today.
It is set for today, Your Honor. I've got amended notice of hearing. It is electronically filed 7/1/2026. And I want to remind the court that the reason we had to even file it was because we were unable
Now
to.
we're getting into the motion, Your Honor. I think we're talking about whether we got
No.
proper
You're
notice.
complaining about how, when it
Complaining
was.
about notice.
If I may, you had your turn, counsel.
I'm complaining about notice.
I can't hear both of you at the same time.
Yeah,
Your
cut
Honor,
it out.
perhaps we could clear up whether notice was even given.
Well, okay, we can do that. Ms. Blackburn, you're here. But you're on mute.
Okay, let me take a look at the file real quick. All right, an amended notice of hearing on petitioner's motion to modify order regarding the marital property appraisals was filed on July 1st. And that notice was not signed by you, Judge. That was signed by Mr. Ullman.
No conference was made with my office or Ms. Torres's office, as I understand, to agree to that setting date. Again, we were on vacation. We agreed to come in on our vacation for matters that were already set by the court and ordered by the court to hold our feet to the fire when a weekend and a federal holiday happened, when we had no opportunity to review this, and we have tried to work it out. We just respectfully request another setting.
If I may, Judge, I have to deal with what I have to deal with. When we tried to timely, we notified them of our expert, of when he wanted to appear, to go down there before the deadline of July 10th. We found out that no one was home. All lawyers were on vacation. Mr. Clark was overseas. I had to do what I had to do.
Your Honor, Mr. Clark is not overseas. He has not been overseas.
We've got,
Please don't interrupt him.
We've got correspondence to counsel alerting him to the expert and when he was going to go down before July 10th, which was the deadline. And we were notified by staff, as I said earlier, that it wasn't going to happen. They were on vacation. I had to do what I had to do. I had to file a motion and had to provide notice. I'm not asking for fees. I'm not asking for punitive action. I'm simply saying we need to get this done. I want the 13th and 14th at least. And we'll, if we are unable to achieve our review and valuation, I will speak to counsel. But it needs to happen and it doesn't need to be delayed anymore and we need to finish this enforcement, Judge. I want a ruling on it today.
So, Your Honor, I would respectfully ask that the court rule on whether we're even proceeding on Mr. Ullman's motion that was apparently set on the 1st while we were on vacation, before we get into the facts of why Mr. Ullman thinks he needs that motion. And then with respect to needing a ruling on the motion for enforcement today, Mr. Clark has not yet presented his case yet. Mr. Ullman has rested. Now it's our turn. And I don't know that we can get it done in the next hour and a half. We have quite a bit to go through. If I said something funny, Mr. Ullman, please let me know. I wouldn't try to be funny. I'm usually not when I try.
Well, and I'm sure y'all are both capable of helping me out on this, but I'm unclear why we have a hearing set in a vacation period that I agreed to honor.
It's because Mr. Ullman pulled that date out of his ear and decided he was going to set it on that day.
Mr. Lopez, that's not appropriate, and you're a better lawyer than that. You need to quit those childish comments like that.
This
It's
case
just-
is this case
Sir?
is exceptionally frustrating, Your Honor.
It's frustrating for me as well, and part of it is your comments like that are just out of bounds, and you need to stop it to help me get this under control. It doesn't add anything to your case to do that, I assure you. I'm gonna honor the vacations. I said I would honor vacations, and I'm going to. Which means that we're not gonna have this as requested. And I don't like it. I want to move the case too, but I wish we had the time to waste just to have y'all tell me how it would be different if you were the judge and how you would set it differently. Y'all want me to start setting time limits on the hearings? On what each side gets to say?
Well, Your Honor, they've been telling you how to do your job through the whole proceeding. What are you talking about?
For how long?
If you're asking me a
30
sincere
minutes
question,
per hearing?
if you're asking a sincere question, Your Honor, I do have an answer, but if it's
It's
just
not
further
sincere.
comment on our approach, then I'll just stay quiet.
It's not sincere. I don't believe in that. I detest it when I try to give the lawyers the freedom to fully present their case as they deem appropriate, but when it's abused, it's extremely offensive. And that is just what I'm seeing going on here. And well, I won't say any more about it. Time to stop. What time is it?
3:45, Your Honor.
All right, what needs to be done? We're waiting on Mr. Clark for 4 o'clock appearance. Is that what we're doing?
Mr. Clark's present in the courtroom, Your Honor. It's just that we had a phone call scheduled with him at the conclusion of today's setting to discuss whatever came up. And we had suggested we could use that time to discuss what Mr. Ullman's asking for.
Judge, I'm willing to wait on that to complete this enforcement on this 4th or 5th day that we've tried to complete it.
All right. And you want to present what from Mr. Clark?
His defense, Your Honor?
His defense on the motion.
Correct.
Let's go. Call him.
I call myself, Your Honor.
We need to swear you in.
I'm not calling Mr. Clark at this time, Your Honor. I'm calling myself.
Why did we agree to have Mr. Clark on the Zoom at 4 o'clock if you're going to testify first?
Maybe that was a misunderstanding. Mr. Clark has been present for the entirety of today's hearing, Your Honor. We had mentioned that Mr. Clark, Ms. Torres, and I have a meeting that was scheduled for the conclusion of today's hearing, just to recap and talk about other issues in the case. Ms. Torres and I had offered to use that time to discuss the request that Mr. Ullman had made. And so we would ask that before the court move forward on Mr. Ullman's motion, at least give us a chance to talk with Mr. Clark about it, which we planned on doing at 4 o'clock. We got further in our discussions than I expected to with Mr. Ullman, but like I said, we came to a hard no at a particular issue. So now that requires the discussion that we had originally told the court we needed to have.
Your Honor, I respectfully request that we complete the enforcement hearing and that I will discuss and table the other issue until after that.
Well, that's fine, Mr. Ullman, but how do you propose that we're going to finish that hearing, that motion? Because you know what's about to happen is Mr. Lopez is going to take an hour or more, and then he'll want to put Mr. Clark on, and we're not going to get there.
Your Honor, at the 2 hearings ago, it is my recollection that counsel said he needed about an hour to finish the cross-examination of their case.
And even if I don't disagree with you, sir, do you wish me to start imposing time limits on people?
That's fine with me.
I would think that would be inappropriate to do after one side has rested and taken 4 days and expect me to try Mr. Clark's entire case in the next hour and 15
Well,
minutes.
it's not the entire case, it's a motion.
Well, his entire response to the 4-day motion that Mr. Ullman has presented, yes.
And you're correct, it's out of balance to do that. I just feel the delay coming on.
Your Honor, I've got a suggestion, and it's in line with some of the, if the court's even willing to consider it, but at the end of the day, what Mr. Clark had testified to, yeah, I spent all the money. We've said it. Okay, hey, look, we're not saying that that wasn't him. It was somebody else that ran the card. There's already claims that are on file in order to make whatever party whole, and that goes both ways. We have claims to make us whole. Wife has claims to make her whole. At the end of the day, the only thing that's different today about this motion for enforcement versus what we would do at trial is that they're seeking jail time, and counsel is seeking $100,000. That's not going to go to Ms. Clark. It's not going to go to the benefit of the children or the estate. It's going to go into him personally. He told the court that. We already got $100,000 3 or 4 weeks ago, minus his credit card processing fees. The court can still take all the testimony that the court has already taken over these 4 days and incorporate that into what would be presented at the final trial. And if at the end of the day, it's $425,000 or whatever number Mr. Ullman says it is, that number gets put in on the spreadsheet and on the division, and we can get past these preliminary hearings that effectively bring the case forward, but keep us bogged down in court.
Judge, if I may, that's just an argument. I'd like to go forward. This 100,000, Judge, I dispersed part of that money to expert, to Ms. Mark Baumgartner. I dispersed portions of Ms. Trends. But that's irrelevant. I would like to finish this hearing. I tried to start a month or 2 months ago through prior counsel, and I would like to finish it, Judge. Please, we can go forward.
We can go forward. We're not going to finish. I can guarantee you that. I'm waiting for the suggestion on how to accomplish that.
All we can do is move forward, Judge. And if I will object if I think it's irrelevant, if it's and try and shorten it if that is an appropriate objection. But all I can do is try and move forward on this case. They have successfully, or it's for various reasons, this enforcement hearing is stretched out over a month and has resulted in a lack of appropriate remedies, in my opinion.
Call your witness, Mr. Lopez.
I call myself.
So ask yourself a question.
Do I have to, or can I do a narrative like Mr. Ullman did?
Well, you can do it in narrative like you objected to before, yes.
Okay, and just to be clear, I only objected to one particular narrative that Mr. Ullman went on, and I'll try to keep my topics succinct to one particular topic. Your Honor, my name is Esteban Lopez Jr. I'm an attorney licensed to practice law in the state of Texas since November of 2009. I am in good standing with the State Bar of Texas. I've never had any adverse disciplinary actions or any suspensions or anything like that. I am board certified to practice, or I'm board certified in family law since 2024. Since about 2012, I have practiced exclusively almost in the area of family law in South Texas, primarily in the area of Corpus Christi, Nueces County, and the surrounding counties, which include Rockport and Aransas County, Texas. I have served as the president of the family law section of the Corpus Christi Bar Association. I've also served as vice president of the Corpus Christi Bar Association. I've served as a course director for advanced family law courses. I have given CLE speeches throughout the state, and I'm routinely appointed as amicus, ad litem, as well as receiver in other complex family law cases. Through my experience and working with clients like Mr. Clark, as well as folks like Ms. Christina Clark in complicated divorce actions in Aransas County, I have come to an opinion of what reasonable and necessary attorney's fees are to be incurred for the type of work that's been performed in this motion for enforcement. And it is of my opinion that the attorney's fees and expert fees that are not necessary for the relief that she is seeking.
You
And
cut
there
out.
are, okay, what about now? What about,
You cut out again.
sorry about that. Testing, testing. Can you hear me okay now?
Yes.
Okay, thank you. I'm not sure where I cut off, but I do believe that the attorney's fees incurred by Ms. Christina Clark on this motion for enforcement are not necessary. They are unreasonable. They are excessive, and they are only to the benefit of the professionals that are charging those fees in this case. Specifically, when I look at the fact that 1,000 alleged violations were filed over 5 pleadings, an original motion for enforcement, amended, and then supplemental, and then only pursuing 56 of those violations, I believe that the attorney's fees that were incurred to investigate, to prepare for, to plead for those other 940 something other violations cannot be reasonable and necessary because they were not even presented to the court. I think that the family law, case law, as I understand it, and as I have practiced it for the majority of my career, does not allow a party to prevail on claims that are not actually proven by preponderance of the evidence before the court. And so I think that what this 1,000 count motion for enforcement that was filed against Mr. Clark, what it essentially did is it put, and I think I made this argument earlier, 56 needles in a 1,000 count haystack. And it kept his attorneys chasing their tails, trying to determine what is going to be important, what's not going to be important, what they're going to be proceeding on, what they're not going to be proceeding on. And it kept us working and incurring attorney's fees that were not necessary to incur, and also went to the detriment of the estate. One thing that I think the court needs to consider in this case is that there's only really one source of all of these funds. And so if Ms. Clark takes an approach in this case that causes her attorney's fees to go up, it also causes Mr. Clark's attorney's fees to go up. The only people in the room that benefit from that type of fighting are the attorneys. We have tried to keep that minimal. That's been our approach in this case, to try to get to the exact issues. Mr. Clark has fallen on the sword when it comes to the individual transactions. He'll tell you, yes, it was me that swiped. Yes, it was my jacket that I bought. Yes, I bought those clothes. Yes, I invested in that business. What we also have that we have not been able to pursue just yet is our motion for enforcement. And what I think you'll see, Your Honor, is that the difference between the alleged violations that we have and the violations that Ms. Clark has is, number one, ours are relatively de minimis to the to the value of the estate. But secondly, many of our violations produced things that can actually turn around and produce income, like bucking bulls or business investments, not just spending for the sake of spending. We also think that there's been sort of a hiding of the ball when an original motion for enforcement is filed, then it's amended, then all of the supplements come through. We are given a handwritten page that says, hey, this is all we're going forward on. Then we're given a proposed order that says, this is all we're going forward on. It wasn't true. There was mistakes in it. They had to take out violations. Then we got 2 more in rapid succession. I received an email from the paralegal working for Mr. Ullman of a table with the violations they intended to proceed. The next day, they amended it again. And this was 2 days before the hearing that we were on vacation when we started. I think that they knew what we were requesting when we said, look, put all of the violations that you want to move forward on one document, the way we can file it and the way we can follow it, the way the judge can follow it. They refused to do that over our request. Your Honor did not order them to do that. But what it did is it created a lot more headache, I think, for the court, certainly for our side, and it caused attorney's fees to be incurred well beyond what is necessary. Additionally, Your Honor, when I'm looking at a 1,000 count violation, but only 56 are pursued, no evidence being offered on the other 940, my understanding as an expert in family law and Texas civil procedure is that you cannot receive relief on claims that evidence is not presented on. And so at this time, we would ask the court to dismiss those as well. But I also offer myself for cross-examination.
Mr. Ullman?
I have no questions.
I have no additional testimony, Your Honor.
Y'all must have something else to do this afternoon.
I do have Mr. Clark to call.
Well, it's time. It's 4:00.
And I'm sorry, Your Honor, I still think that we might be confused. Or when I say call him, I mean to call him as a witness.
Call him.
Thank you. Mr. Clark, are you there? You're on mute, sir.
I'm here.
Hey, Mr. Clark, I'll remind you that you're under oath.
Yes, sir.
Hey, what time is it in Europe?
That's a good question. I'd have to look up my phone I'm not in Europe. I'm in the United States.
Oh, you didn't fly anywhere internationally?
No, sir.
Why is Mr. Ullman lying about you like that?
I think I asked Christina if I could take the kids to Paris, but I meant Paris, Texas. I didn't mean Paris, France. And
Okay.
I need to
And-
swear him in.
ma'am?
I need to swear you in.
Oh.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Thank you.
All right, Mr. Clark, I'll ask you again. You're not in Europe.
No.
Okay. When's the last time you've been to Europe?
Year or two? I don't know. Somewhere. Been a while. I'm broke these days. So
Okay. And I think you had said that you had asked Ms. Clark if you could take the children to Paris, Texas. Is that right?
yes, sir.
Okay. And she said no.
She gave me a long list of requirements I just wanted a yes or no. And she gave me a long list of requirements that I needed to meet of hers to get the kids to go with me.
Objection, relevance.
Just
Just trying to, okay. Do you know any other reason why Ms. Clark might think that you're in Europe or might have told her attorney to tell the court that?
No.
Okay. Could you even afford to go to Europe right now if you need to?
I could use my points, but no, I couldn't afford just tickets right now, not with what I make a month.
During Mr. Ullman's testimony, he was not sure what, if any, kind of relationship the children that went on the Florida trip have with Miss Clark. Did you hear that?
I did. Surprised.
Do you know what kind of relationship the children that went to Florida have with Miss Clark?
Well, they were at her house Thanksgiving.
Okay. Are they children of a dating partner of hers?
Yes, they're the children of her boyfriend.
Okay. I had asked Mr. Ullman whether there had been sort of a couple swap in your case. Would that be a fair way to shorthand describe it?
I mean, not from my side. I was already dating Lauren. She found out about Lauren and contacted Mr. Stanley on Facebook.
Okay. And so these kids that you took, they're kids that also
Say hi.
in
They're
the same household. Go ahead.
yes, Sadie and Summer Pinkston.
Okay.
Stanley Joe Pinkston.
Mr. Ullman doesn't know how much money you spent in Florida. How much would you estimate you spent on that trip?
Well, I mean, I spent money for myself because I had to feed myself. So not all the charges, but I did buy, if they bought me, I didn't pay for the hotel or the trip. So I used my points for the plane tickets as a trade because the hotels are expensive. And so I would buy, refreshments, and then I'd buy refreshments for them because they bought refreshments for me because Disney's expensive. So I maybe $1,000, $1,200 in refreshments and toys maybe. And I bought some stuff for my kids too on that, but I have them at the office.
Mr. Clark, you don't deny that you spent the way that Mr. Ullman alleges that you did.
Not at all.
Okay. And in fact, you stood up on the witness stand, and I think you just about agreed to every one of his alleged violations he had asked you about.
Yes, sir.
Okay. Is it your position that spending was in line with how you spent since you've been in business for yourself?
Yes, sir.
Okay.
And we have spreadsheets to show it every year what I spend, and every single violation there's a comparable one for many years.
Now, Mr. Ullman has suggested that you go to jail on the weekends between now and trial.
Yes, sir.
How is that going to affect your ability to work and earn and support everybody in this case?
Well, if they read the contract I have with the city of Corpus, we don't even need to have the trial in August because there's going to be no estate if I go to jail.
What do you mean by that?
We have a contract with the city's IDIQ contract, and we have a bond through SureTech, and I have to be available 24/7 for emergencies
Objection,
for the city.
hearsay.
It's in the contract. I mean,
Objection,
on.
hearsay.
I can ask him different. What is your understanding of your responsibilities and how those are affected by incarceration?
I've been doing the IDIQ contracts for 10 years, over 10 years. And I'm the very first one that did them in the city of Corpus. So I know the contracts probably better than anybody as a contractor. And when we decide to sign the contract and to sign the bonds, we have an emergency clause that says
Objection,
myself.
hearsay.
It's okay.
Don't tell me what the contract actually says. Just tell me what your understanding of what would happen to your ability to earn if you were
Okay.
incarcerated for.
We go out of business.
Okay. And is that a short-term consequence or is that permanent?
It's a bonding claim, so it's a permanent. No more. All of our assets that we signed the indemnity agreement, and the business is gone.
You're one of the corporate attorneys in this case, Mr. Powers, when he appeared, had suggested to the court that rather than having the entities involved in the case, just total up what it is that you spent and put it on your end of the spreadsheet. Do you recall when Mr. Powers made that argument?
Yes, sir.
And you've heard Ms. Torres and I make pretty much the same argument, right?
Yes, sir. I thought if somebody has an issue, it's 50-50 anyway. So if I spent 400, they don't like, they just put basically 200 is mine anyway. So correct. I don't know.
It'd be like you got it early.
There you go.
Do you know what benefit to the estate would come if you paid Mr. Ullman $100,000 just to go into his?
Well, that's kind of basically when I pay attorneys, I make no money, and I have no money to make money. When I buy other stuff, I have ways to make money. So no, the attorney fees are really hard. That's why I haven't been doing extra stuff. Steve, you're on. You're frozen.
Mr. Lopez, we've lost you.
Maybe he's rebooting.
There he comes.
There you are, Steve.
Sorry about that, Judge. I got disconnected. I don't know if you heard my last question, Mr. Clark, on what benefit to the estate would come by paying Mr. Ullman $100,000.
That's not good for us.
Have you also spent attorney's fees having to defend this motion for enforcement?
I'm not sure what you guys have charged. I know what I've totaled in this case so far.
Okay. But you have paid Deanne and I, or Ms. Torres and I, to work on defending this enforcement, correct?
Yes, sir.
And do you have an opinion or understanding of whether it's more or less expensive to defend against a 1,000 count violation enforcement versus a 56 count violation?
I would think that'd be like 10 hours to an hour would be my guess.
Your Honor, past witness.
Mr. Ullman, anything?
Mr. Clark, do you recall sending a text to your wife on June 24th, 26th that stated Lauren offered to take the kids with us on a vacay out of the country if they want, since she's paying her kids are going?
Yes, sir.
And you recall stating on 6/24/26, she's thinking Paris, 1st of July.
Yes, sir.
Okay, no further questions.
Past witness.
Oh, but Texas seceded. That's got to be it. Because he was referring to Paris, Texas, not Paris, France. Don't misunderstand his text messages that he just admitted he sent.
I have no questions.
Witnesses?
No additional witnesses, Your Honor.
You mean we're finished?
We're finished.
Except for me. All right, here's what we're gonna do. It's 4:09. We've absolutely shocked me by being finished before 5 o'clock. And I'm gonna take the liberty of using this remaining time to come up with my ruling on these two matters, on this matter. And hopefully be able to email it to y'all this afternoon. And we'll go from there. Any questions?
No,
Okay.
thank you, Your Honor.
No, sir.
No,
Have
Your
a
Honor.
good afternoon.
Thank you.
Thank you.
Thank you.
May I be excused, Your Honor?
Everybody can be excused.
Thank
Okay.
you, Your Honor.
Judge.
Oh, that was fun. I thought that was fun. I know it wasn't everybody's cup of tea, but you can't please everybody. It was a change of pace from what we normally do. Oh, I know. I think it's possible to get the decision. It might take a few days for it to be visible on the court side of things, but I will try. And it's irritating because I know I saw the last hearing, parts of it. And I remember they were questioning Mr. Clark about getting access to some building and about him providing access and giving them the keys before the 13th. I remember that. I also remember thinking, oh gosh, this is so boring. I didn't, like, normally I'll download something even if it's boring. I think I opted not to download it because I'm running out of storage space. And so I was trying to selectively pick. And that's on me. So, lesson learned. Whether I think I want it or not, I'm going to get it. Pretty sure it's going to go against Mr. Lopez, whatever it is. Judge was not a fan. Yeah. Well, give me 2 seconds. Oh no, because I'll have to go back. No, I'll look it up. Just not right now. I'm tired. I know, but they're so expensive. I'm working on it. I'm working on it, one thing at a time, Penny. Thank you guys so much for coming and hanging out with me. I love you guys all so much. I'm going to go lay down now. Be safe, be well, sleep sweet, and much love.